Hi, everyone. Thank you for joining us again tonight for our third virtual community session. If you haven't seen any of our other two videos, my name is Crystal Dory, and I am the Communications Manager for KMK. As you all know, because of COVID-19, we are still doing things virtually and finding ways to reach community members in new ways because we know how important it is to keep community members updated on the work of KMKNO. So for the past two sessions, we have done live sessions. Because this is something new and we're trying different techniques, we're actually going to do this one as a pre-recording. You will see that because it's pre-recorded, there are no Q&A part of tonight's segment, but that doesn't mean you can't ask questions. Please feel free to send in any questions you may have following this presentation to info@migmarights.com, and they will come to me, and I will certainly find somebody on the team who can help answer your questions. So as we've noted in previous months, we are going to have a different focus every month and try to keep things fresh and interesting for all our viewers. We also have an accompanying newsletter, which goes out just before the community session, and one will have just come out before this community session, and we'll continue to do that every month. And you can find that on our website at migmarights.com, or again, send me an email and I'll make sure that you get added to our distribution list. So this month's session will focus on an introduction on Migma, Aboriginal Title, and Treaty Rights with our senior researcher, Gillian Allen. Gillian joined the KMKNO team in 2007, and this year actually will mark 28 years for Gillian working with the Migma. One of the reasons that this session is being pre-recorded, which we are saddened but excited to say, is that Gillian is actually retiring. Today, March 31st, the day you're watching this video, is Gillian's last day at KMKNO. We wish her all the best in her retirement. She has been an incredible asset to the Mi'kmaq of Nova Scotia. Her knowledge on rights and title and the research she's done to help us learn more about our history has been invaluable to the nation, and she will be missed. But I'm glad that on her technically very last day with KMKNO, we have an opportunity to speak to her and hear more from her and be able to record this presentation for all of us to see and to keep, because this knowledge that she is sharing with us tonight is so incredible. As I said, questions will undoubtedly arise from this. So we encourage everyone to send your email in, ask your questions, and we will find somebody on the team who can answer the questions, although we know that Gillian will probably be getting lots of rest and relaxation and enjoying her retirement at this point. So without further ado, I will throw it over to Gillian, and Gillian is going to do an amazing presentation for us. Thank you, Gillian.
And thank you, Crystal. Thank you particularly for those lovely words. I'm touched. So today, or this evening, we're going to talk about four things. We'll talk about Mi'kmaq Aboriginal Title. We'll talk about Mi'kmaq Aboriginal Rights, Mi'kmaq Treaty Rights, and Consultation. Now, this is necessarily a very, very short summary, which is only scratching the surface in a very complicated field of law. But we'll try and give you as much information as we can in the time span we have. So what are Mi'kmaq rights and what is Mi'kmaq title? So we all know the Mi'kmaq possess constitutionally protected rights. So what does it mean to possess Aboriginal and treaty rights? And what does it mean to say that Mi'kmaq have Mi'kmaq title to Mi'kmaq lands? Where do these things come from? In 1996, the Supreme Court of Canada declared that Aboriginal title and rights, as affirmed by Section 35 of the Constitution Act, exist. And I quote, because of one simple fact: when Europeans arrived in North America, Aboriginal peoples were already here, living in communities on the land, participating in distinctive cultures, as they had done for centuries. It is this fact, and this fact above all others, which separates Aboriginal peoples from all other minority groups in Canadian society, and which mandates their special legal and now constitutional status. So the constitutional protection under Section 35 of the Constitution Act 1982 states that the existing Aboriginal and treaty rights of Aboriginal peoples of Canada are hereby recognized and affirmed. Therefore, Aboriginal peoples, including Mi'kmaq, cannot be unilaterally stripped of their rights or Aboriginal title by the Crown. The federal or provincial governments cannot extinguish rights. However, the exercise of rights can be limited or, in the words of the court, be infringed in certain circumstances, but those limitations must be as minimal as possible. Mi'kmaq rights and title are communal. That is, the rights and the title of the Mi'kmaq Nation are owned by the collective. It is the nation that holds the title and rights, although Mi'kmaq individually engage in Aboriginal or treaty right harvesting. Now, Aboriginal title. Mi'kmaq title is the communal right to the land itself. Mi'kmaq have an Aboriginal title claim to all of Nova Scotia. Although technically Aboriginal title is a type of Aboriginal right, but there are different rules and different key dates for determining Aboriginal title, so we generally treat it as something a little different. So Mi'kmaq title comes from Mi'kmaq use and occupation of their lands before the British Crown declared its sovereignty over Mi'kma'ki. Mi'kmaq have never surrendered, ceded, or sold the Aboriginal title to any of their lands and waters in Nova Scotia or indeed anywhere else in Mi'kma'ki. Aboriginal title is critically important because, unlike Aboriginal rights, which we'll talk about shortly, title gives Mi'kmaq rights to and control over the lands and waters themselves, and not just a right to engage in a particular activity. Now, Mi'kmaq title is different from a private property title held by non-Mi'kmaq. There are a number of unique features to Aboriginal title. One, because Mi'kmaq people collectively hold Aboriginal title to their lands, only the group or the collective can authorize giving up title to the land. All Mi'kmaq must decide together if they choose to give up some or all of their lands. Now, this doesn't mean that the decision has to be unanimous. It just means all Mi'kmaq must decide together. Secondly, Aboriginal title lands can only be sold or given up to the federal government. Just like reserve lands, which can only be surrendered to the Crown, Mi'kmaq cannot pass Mi'kmaq title to private interests or to a provincial or municipal government. Finally, thirdly, Mi'kmaq title is a responsibility to the lands and the waters, and to the ancestors, to the Mi'kmaq of today, and to their descendants. And because of their relationship with their territory, their lands and waters cannot be used in a way that is inconsistent with continuing the values those lands and waters had in the past. Mi'kmaq lands and waters have an integral value that cannot be destroyed in a way that would make it impossible for their descendants to benefit from those lands and waters. But that is not to say that Mi'kmaq use of lands and waters must be limited to using resources only for traditional practices. Mi'kmaq title means the right to use and occupy lands and waters for a variety of purposes, not just those which are customs and traditions integral to Mi'kmaq culture. So Mi'kmaq are entitled to develop plans for their traditional territory, not only about such things as hunting, fishing, and trapping. Mi'kmaq title encompasses mineral rights, and Mi'kmaq title lands and waters can be exploited and developed in 21st century ways by Mi'kmaq. Mi'kmaq title is the right to choose to what ends lands and waters can be put. Now, one of the things we have, of course, is proving Aboriginal title. And one principle guiding title cases, rights cases, treaty cases is that the courts are supposed to reconcile, and take account not only of British-derived law, that is what our Canadian legal system runs on, but the courts are also supposed to take account of laws, in this case, of the Mi'kmaq Nation. Now, part of what each of us in the research department does is to gather the evidence which supports the Mi'kmaq assertions of Aboriginal title. And of course, because there are courts involved, there is a test. It's a three-part test to determine if you hold Aboriginal title. First, the land must have been occupied prior to sovereignty. On mainland Nova Scotia, the courts have said that the date of British sovereignty is 1713. In Cape Breton, it is 1763. Secondly, if present occupation, i.e. the fact that the Mi'kmaq are here now and living in their lands and using the resources of their lands and waters, if you're using that present occupation as proof of pre-sovereignty, that is before 1713 or 1763, there must be continuity between the present and the pre-sovereignty occupation. Because of problems like our acidic soils, which degrade things such as leather or bone or vegetable matter very quickly, part of the evidence to link the present Mi'kmaq Nation with the pre-sovereignty Mi'kmaq must be found in the oral evidence and in documents which record the Mi'kmaq presence on the lands and waters. This evidence and the historical documentation can provide the bridge from the archaeological evidence to the present. And finally, the third element of the test to determine if a nation has Aboriginal title is that the occupation must have been exclusive. Now, exclusive does not mean that the lands could not have been shared with other First Nations. For the Mi'kmaq, for example, in Newfoundland, in the Gaspé, in PEI, in Nova Scotia, it's not difficult to find that there was exclusive occupation. In New Brunswick, the Mi'kmaq and the Wolastoqiyik are often at odds with the federal government and the provincial government about which parts of the province are Mi'kmaqi, which parts are Wolastoqiyik, and which parts were shared by the two nations, each of whom is entitled to claim their exclusive occupation in that shared area. In 2014, the Supreme Court of Canada released the Consultation decision, and the court set out what constitutes sufficient occupation to ground or prove title. And I'm going to read you a bit of an extended quote, but I think the court says it much better than I can. So in Consultation, the court said, in summary, what is required is a culturally sensitive approach to sufficiency of occupation based on the dual perspectives of the Aboriginal group in question, its laws, practices, size, technological ability, and the character of the land claimed, and the common law notion of possession as a basis for title. It is not possible to list every indicia of occupation that might apply in a particular case. The common law test for possession, which requires an intention to occupy or hold land for the purposes of the occupant, must be considered alongside the perspective of the Aboriginal group, which, depending on its size and manner of living, might conceive of possession of land in a somewhat different manner than did the common law. There is no suggestion in the jurisprudence or scholarship that Aboriginal title is confined to specific village sites or farms. Rather, a culturally sensitive approach suggests that regular use of territories for hunting, fishing, trapping, and foraging is sufficient to ground Aboriginal title, provided that such use on the facts of a particular case evinces an intention on the part of the Aboriginal group to hold or possess the land in a manner comparable to what would be required to establish title at common law. Now, this is very good news for societies such as the Mi'kmaq, as it recognizes forager society use and occupation patterns, which are often fluid and seasonal. And just because Mi'kmaq did not establish permanent villages and engage in agriculture in the way, for example, the Haudenosaunee do, that does not mean Mi'kmaq do not have sufficient use and occupation of their lands to ground their title. So now, having had a brief examination of title, we'll turn to Mi'kmaq Aboriginal rights. Aboriginal rights other than title are founded upon the practices, customs, or traditions which are integral to the distinctive pre-contact culture of an Aboriginal people. In Nova Scotia, that means it was the activities, practices, cultural norms of the Mi'kmaq more than 500 years ago. Because remember, the first contact in Nova Scotia likely occurred in the 14 or 1500s. And there also must be the continuity between the present activity and the pre-contact activity if it is to be protected as an Aboriginal right. Again, so what did the court mean when they said this little gem? In a case called Vanderpeet, the court said that present practices, customs, and traditions which can be identified as having continuity with the practices, customs, and traditions that existed prior to contact that will be the basis for the identification and definition of Aboriginal rights under Section 35(1), where an Aboriginal community can demonstrate that a particular practice, custom, or tradition is integral to its distinctive culture today, and that this practice, custom, or tradition has continuity with the practices, customs, and traditions of pre-contact times, that community will have demonstrated that the practice, custom, or tradition is an Aboriginal right for the purposes of Section 35(1). Mi'kmaq Aboriginal rights, practices, traditions, and customs from before contact with Europeans include, for example, the right to a food, social, and ceremonial harvest. For example, the annual moose hunt on Hunter's Mountain. Another Aboriginal right is the right to harvest wood for domestic purposes. That is the right to cut wood to build a home. The right to govern yourself and your community. Mi'kmaq have a right to self-governance. And another example is the Mi'kmaq right to practice Mi'kmaq culture and customs, including language. Now, back in 2002, one of our colleagues here at KMK, Alison Bernard, went to court on an Aboriginal rights case, and the Nova Scotia Court of Appeal affirmed that he, and therefore all Mi'kmaq, have an Aboriginal right to hunt for food in Nova Scotia. Now, the exercise of an Aboriginal right can take a modern form. Mi'kmaq are not required to make bows and arrows to harvest game. They are not required to construct seagoing birch bark canoes to get lobster. The gear that is used in the harvest, for example, as an Aboriginal right, can be contemporary gear. So just because the right arose 500 years ago, you are not limited to exercising that right with 500-year-old technology. Now, one thing with an Aboriginal right or a treaty right is that the Crown can limit or infringe rights. For example, the government may limit what gear is used to fish, the type of shot used when bird hunting, or impose a quota on how many deer may be taken for food, social, and ceremonial purposes. However, any limits imposed on the exercise of an Aboriginal or a treaty right must be justifiable. And to be justifiable, the Crown must have had a valid reason for limiting the Aboriginal right. The reason for the law or the limit, the legislative objective, must be compelling and substantial. Just saying that a law or a regulation was passed in the public interest isn't enough. As an example, the courts have consistently said that conservation is a valid and compelling legislative objective. So how do we determine if this limit is reasonable? We must ask, 1, did the Crown have a just reason for their decision? 2, did the Crown fulfill their duties and responsibilities to the affected Aboriginal people, such as did they engage with the community? How did they respond to the community's concerns? Did they work together with that rights holding group in a fair manner? In other words, did the Crown treat the affected Aboriginal people in a manner consistent with the honor of the Crown. And when we talk about the harvesting Aboriginal right, there is what's called a Doctrine of Priority. And when apportioning quota or setting limits, infringing on the right, the priority must look like this. And it would be the first priority is Aboriginal food, social, and ceremonial harvesting. That must be recognized right. Secondly, the Aboriginal right commercial harvesting or a treaty right moderate livelihood harvesting, for example, is second in the queue. Third comes non-Aboriginal commercial harvesting, and fourth is recreational harvesting. So if there is a need to conserve a species, that's the priority in which access to the harvested species is to be allocated. And this doctrine is based on what's called the internal limits of the right. A food, social, and ceremonial harvesting right, in effect, limits itself because there's only so many moose or so many deer, so many rabbits, so many fish that any one Migma needs to meet her or his food, social, and ceremonial needs. So to determine if the process of quota allocation and the actual allocation of a resource was a justified infringement of an Aboriginal right, at a minimum, there are three factors to be considered. First and foremost, was there absolutely as little infringement on that Aboriginal right as possible? Secondly, did the government consult with the affected Aboriginal people before infringing their right? Now, the scope and the amount of consultation will vary depending on the type of right that's being infringed and the extent or the impact of the infringement. And finally, another consideration is, did the government or the Crown provide adequate compensation for infringing the Aboriginal or treaty right of the affected Aboriginal group? As with Aboriginal title, we also have proving Aboriginal rights. Now, the key time frame for an Aboriginal right is determining if an activity was conducted or undertaken pre-contact. That is, was it an activity engaged in by Mi'kmaq before the Europeans arrived here? And as noted above, in 1996, when the Supreme Court ruled that determining which practices, customs, or traditions constitute a right, they are those that have to have continuity with the practices of the past before the Europeans arrived here. Therefore, in our office, our approach to gathering evidence in support of both Mi'kmaq title and Mi'kmaq Aboriginal rights is to gather absolutely everything we can lay our hands on that demonstrates Mi'kmaq use and occupation of their lands and waters and provides descriptions of the activities, customs, traditions, and practices from time immemorial to the present. Now, one difficulty with gathering the written information lies with the subject matter of the written records. To record Mi'kmaq practices, customs, and traditions that have been engaged in since pre-contact times, there's a number of elements which must be present. First, there had to have been somebody here to record the activity, and often there wasn't. Before the Loyalists arrived in the 1780s, there were very, very few non-Mi'kmaq present in what is now Nova Scotia. So there weren't a lot of people around to observe what the Mi'kmaq were doing in their daily lives. Secondly, that observer must have been literate, i.e. that person who was observing the Mi'kmaq activities or taking part in them with their Mi'kmaq neighbors had to have been able to read and write. And at this point, very few people in Nova Scotia could. Thirdly, the observer must have been interested in day-to-day Mi'kmaq activities, customs, practices. Most observers weren't. What they were really interested in was the number of Mi'kmaq warriors who could be called upon in the innumerable battles between the French and the English in what is now real lives was really of very little interest to most of the writers. So the record they've left us, we really have to tease things apart to find the information we want in support of Aboriginal title and Aboriginal rights claims. And finally, and most obviously, even if there was someone literate, even if there was someone interested in what Mi'kmaq were doing in their day-to-day lives, even if they did write it down, that record had to survive. That it didn't get destroyed by mildew in our lovely damp climate, that it wasn't chewed up by the rats, that it wasn't thrown out by somebody's kids who said, oh, who wants grandpa's diary? No one does. Good, put it on the bonfire. So those are some of the constraints we have in doing our research. But together with our colleagues from the Archaeological Research Division, are phenomenal people there. We scour the archaeological records, the written historical records. We undertake new archaeology projects, and we collect the oral evidence from the Mi'kmaq elders and knowledge keepers to try and fill the gaps in our understanding so that we can demonstrate which practices, customs, and traditions are rights of the Mi'kmaq people. Now I'd like to turn to treaty rights. And we are going to make reference in most part to those of stemming from 1760 and 61. And as most of you know, that in 1760-61, Mi'kmaq communities across what is now Nova Scotia and New Brunswick signed a series of peace and friendship treaties with the Crown. And in 1999, the Supreme Court of Canada, in the Marshall decision, affirmed that these treaties have never been cancelled or annulled, and they remain in full force and effect. Now, the most significant clause of these treaties is the so-called Truckhouse Clause. In that Truckhouse Clause, the government promised to set up truck houses, i.e. places to trade, where Mi'kmaq could trade their goods for fair prices, and in turn, the Mi'kmaq promised that we will not, this is the language of the 1760s, traffic, barter, or exchange any commodities in any manner, but with such persons or managers of such truck houses as shall be appointed or established by His Majesty's government at Lunenburg or elsewhere in Nova Scotia or Acadia. So, according to the Supreme Court of Canada, this promise to establish truck houses and the Mi'kmaq promise to trade only at the truck house is the equivalent of a right to trade for necessaries. Specifically, Mi'kmaq have the continued right to harvest and sell what kinds of products they would have had to harvest and sell in the 1760s. And the Supreme Court of Canada has said that this moderate livelihood, well, it includes basics such as food, clothing, housing, supplemented by a few amenities, but it is not the full accumulation of wealth. So the right to a moderate livelihood is not a general right to trade for large economic gains. And unfortunately, as we all know, the Mi'kmaq are still waiting for the Crown to fully implement the moderate livelihood right. And as an aside, Crystal mentioned in the introduction that I began work about 28 years ago. My first work with the Migma of Nova Scotia began in 1993, where one of the first projects I was working on was Junior Marshall's case at provincial court, which started the march on the way to the 1999 Marshall decision. So I feel, in a sense, my career is being bookended by Junior Marshall and by lobster and eels. I started with them, and I'm going out with them. So, are all natural resources and foodstuffs covered by the peace and friendship treaties? Short answer, no. The list of items which Mi'kmaq can harvest and sell to earn a moderate livelihood does not extend, for example, to logs. What the Supreme Court said was when the treaties were signed back in the 1760s, there was so much wood around that incoming non-Mi'kmaq settlers and colonists would not have had to trade with Mi'kmaq to get wood for building their homes, building barns, for their fireplaces. So therefore, commercial logging, as we know it today, is not a treaty right under the 1760 treaties. The court held that while the treaty protected Mi'kmaq rights to harvest and dispose of some items, cutting and selling commercial logging was not a logical evolution of a traditional trading activity. And that was in the Marshall and Bernard case of 2005. Now, the exercise of treaty rights, like the exercise of Aboriginal rights, can be limited. The Crown may limit or infringe the right to a moderate livelihood, but there has to be an overriding public purposes for limiting the exercise of the right. And any infringement must be the absolute minimum needed to meet that public objective, and the Aboriginal group must be consulted before their treaty right is limited. Finally, the court did add that resources which are harvested pursuant to a treaty right to obtain a moderate livelihood must be equitably shared with non-Mi'kmaq. And that, of course, is just a given from a Mi'kmaq perspective, that we will share. That is, as I understand Mi'kmaq culture, and the privilege I've had for working with Migma for 28 years, that is a core tenet of Mi'kmaq society. We share what we have, and nobody goes hungry. So one characteristic of a Mi'kmaq treaty right to a moderate livelihood that differs from the Wolastoq and the Passamaquoddy treaty rights stemming from those same treaties is the geographic extent of the Mi'kmaq treaty right. So in 1760-61, when the Wolastoq and the Passamaquoddy representatives signed treaties, they signed on behalf of their whole nations. So within their respective territories, a Wolastoq or a Passamaquoddy may hunt or fish or harvest anywhere in their traditional territory. Well, Mi'kmaq didn't approach the treaty negotiations in quite the same way. So Mi'kmaq representatives signed what the court has called a series of separate but similar treaties. That is, Mi'kmaq leaders signed only on behalf of their own communities. The court decided that this means each Mi'kmaq treaty has a geographic limit. The court said that each treaty was local and the reciprocal benefits of the treaty were therefore local. So therefore, for Mi'kmaq, treaty rights under the 1760-61 treaties can only be exercised in the area traditionally used by the local community. And as treaty rights do not belong to individuals, the exercise of the treaty right can only be exercised by an individual with the permission of the local authority in the individual's community, and can only be exercised within the geographic limits of that local community's authority. Now, the Assembly of Nova Scotia Mi'kmaq Chiefs does not agree with this interpretation, and they have argued and believe instead that all Nova Scotia Mi'kmaq may exercise their rights throughout Nova Scotia, and this issue remains a live issue for negotiations. Now I'm going to turn briefly to consultation, just to give you the background on it, because one of my colleagues, I understand, will be presenting one of these sessions on consultation later in the community session series. So what is consultation? Basically, the federal and provincial governments have yet to acknowledge or agree that Mi'kmaq have title to Mi'kmaq lands. However, they do acknowledge that Mi'kmaq have asserted title to their lands, and they also have some confirmed rights, like the right to a moderate livelihood, like the right to a food, social, and ceremonial harvest, and they have asserted other Aboriginal rights. Therefore, according to the courts, the federal and provincial governments owe a duty to consult the Mi'kmaq if any policy, decision, or action of the government could affect title or rights. And in 1990, in the Sparrow case, the court said that while the exercise of an Aboriginal right can be limited, before doing so, the Aboriginal people must be consulted. Then in 2004, 14 years later, in the Haida Nation and Taku River decisions, the court came down even more strongly on this point. So the Crowns have a constitutional duty to consult in good faith with Aboriginal people when making a decision that could potentially affect the exercise of an Aboriginal or treaty right or negatively affect title. If harvesting is affected, if you're going to put a big old sand pit somewhere in an area, then the government must discuss this with the Mi'kmaq, and they also have a duty to accommodate the affected band or Aboriginal group or First Nation if possible. So now this duty to consult exists to protect collective rights of Aboriginal people. The Crown has a duty to accommodate as well as to consult, and that is it has a duty to make provision for measures which mitigate or compensate the Aboriginal group for consequences resulting from a decision. Basically, consultation is not a veto. If the parties do not agree, the Crown can still go ahead and do what it was going to do, even if the Aboriginal group doesn't agree. The only possible exception to this could be where the First Nation or Inuit group has proven Aboriginal title. And in the Kolsutin case from 2014, the court appeared to be signaling that if you have established Aboriginal title, maybe you will have a veto. We don't know. The court has also said where the Crown has knowledge of proven or asserted rights or title, it must consult the group before making a decision, before doing something like, for example, issuing a watercourse alteration permit or implementing a forest conservation policy. Also with consultation, you can't go back. If there was previous inadequate consultation in the past, you can't reopen it unless there's a new, what they call triggering factor. So in a case called Rio Tinto, the court said that, well, matters from a decade ago can't be reopened, but if there was a new triggering factor, like a change in the way, in this case, a dam was operating, then there must be new consultation. The courts have also told us that the Crown doesn't have to consult before changing or bringing in new legislation. And a question we often get asked here is, does an administrative decision maker, like the National Energy Board or the Nova Scotia Utilities and Review Board, have a duty to either consult directly with, in this case, the Migma, on behalf of the Crown, or do they have a duty to review if the consultation was done correctly? The short answer is maybe. It really depends on the way the legislation or the rules establishing that administrative body, like the National Energy Board, which is now the Canadian Energy Regulator, or the Nova Scotia Utilities and Review Board was set up. What kind of power does it have? So it's a sort of case by case to see if there's a duty to consult by an administrative body. Now, the level of consultation will vary with how significant the impact may be on Aboriginal title and rights and treaty rights. If it's something minor, you're going to widen a road by 1.5 feet for safety purposes, probably enough to send a letter advising where, when, and how the work is taking place. But if it's something larger, like say altering a wetland or waters in a sensitive waterway like the Margaree, or in a culturally significant region like the Gaspereau Lake, well then what's called deep consultation is what's required, which means there's a lot more than just writing a letter and saying, hey, we're going to do this. Interestingly, the courts have said that municipalities do not have a duty to consult, only the federal government and the provincial government. And that's because, the reasoning escapes me, municipalities are creatures of the province. They're only established by statute, so they don't have a duty to consult. And as I just said, only the Crown has the duty. Private parties do not have a duty to consult with, in our case, the Mi'kmaq. But the courts, just to confuse everyone, made it a little odd. They did say in the Haida and Taku River decisions that, well, only the Crown has the duty to consult. The Crown may delegate what they call procedural aspects of consultation to people like project proponents, because those proponents have the most intimate knowledge of a specific project. Well, what does this mean? Well, no one knows for sure because the courts have never defined what is a procedural aspect. And as I'm sure you will hear more about from my colleagues who are in the consultation department of KMK, they are in discussions with the Crowns, trying to see if we can hammer out an agreement so that everybody knows what's a procedural aspect and what is a non-procedural aspect to make consultations flow more smoothly. Now, there's also another type of interaction. Proponents, the people who are building a project, like Nova Scotia Power Corp, if it's building or replacing or repairing a dam, doesn't have a duty to consult. There are interactions between proponents and Aboriginal groups such as the Migma. And this is where another of our colleagues comes in, and that is the Benefits Office. So proponents are making money off Mi'kmaq lands and resources. So on behalf of the Mi'kmaq of Nova Scotia, the KMK Benefits Office negotiates what are broadly known as impact benefit agreements to ensure that the Mi'kmaq benefit from developments happening on their lands and using their resources. So finally, in conclusion, I'd like to say that on behalf of the Nova Scotia Mi'kmaq, KMK continues to move forward on rights implementation, such as the Mi'kmaq self-governance, social assistance on reserve. We work on defining and determining who is a Mi'kmaq on behalf of, for the purposes of Mi'kmaq title. We continue to work on the Aboriginal title claim and slog away gathering all the research. And the office conducts consultation on behalf of its member communities. And we have always been mindful that our work is on behalf of all Mi'kmaq of Nova Scotia, and that it is our responsibility in KMK to ensure that all that we do in pursuing full implementation of Mi'kmaq title and rights is done right. It may seem that it's slow going sometimes, but these matters are so very important that my colleagues and we must ensure that what we are doing is thorough and that we have done our absolute best on behalf of the more than 15,000 Mi'kmaq of Nova Scotia for whom we work. And I thank you for giving me the time this evening to speak with you.
Thank you, Jillian. To no surprise, that was an incredible presentation. And I swear that every time I hear you give that presentation, I learn new things. So I appreciate it, and I appreciate your time.
Yep.
So everyone, I thank you for listening, and I hope that you too learned some new information tonight. And as I said, you can always send in any questions to us if you have questions that you'd like to ask anybody on our team. Jillian did a wonderful job of introducing what the consultation process is. And as she had mentioned, there will be future sessions coming up with other departments, including consultation, including benefits. So we definitely ask you to watch for those coming out. And because this is something new and we are learning how to do this and how to reach people, you might see it coming out in different formats, as we had said, this one being pre-recorded, or in the future, they may be at different times of the day. We would like to know that we're accessing and giving that information to as many people as possible, because it's important for our office that everyone can learn this information, has the opportunity to listen in and to ask any questions they may have. So thank you, Jillian, once again for your time. Thank you for everything that you have given the Mi'kmaq Nation and KMK. We so appreciate it. We've appreciated everything you've done, and we send you off with the best wishes we possibly can into an amazing retirement. You certainly deserve it. Thank you, everyone. Good night, and we look forward to seeing you again next month.